Good morning. I hereby call to order this sixth meeting of the Pennsylvania Public Utility Commission for the year 2022, and I realized I never gavelled in, right? But you guys got the gist of it, right? Welcome to everyone that is here with us and who is watching us through our live stream. We ask that you please stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. At today's meeting, which is open to the public, the Commission will act upon various matters. Just as a reminder, there is no opportunity for the public to address the Commission at this public meeting. The public meeting motions, statements, and video will be available on the Commission's website later today. So our first matter for this morning's agenda is the approval of the minutes from March 10th, 2022, and I turn to Commissioner Unora, who is the editor of the minutes.
Thank you, Madam Chair. I have reviewed the minutes of the March 10th, 2022 public meeting and move that they're approved as submitted.
You have heard the motion to approve the minutes. Is there a second?
Second.
Any discussion or further edits? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? Motion passes 3-0. The minutes are approved. So this time I will turn it over to our Secretary, Rosemary Chiavetta, who will lead us through this morning's agenda.
Good morning, Madam Chairman and Commissioners, your various bureaus and offices. Offer the following agenda items for your consideration. Therefore, let us begin on page 1 and matters presented by Director Monahan and the Bureau of Audits. It is recommended that the Commission adopt in an omnibus motion both items on page 1, beginning with the Energy Efficiency and Conservation Charge Audit of the Metropolitan Edison Company, and continuing the omnibus on page 2 to include both items on page 2, ending the omnibus with the Energy Efficiency and Conservation Charge Audit of the West Penn Power Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 3-0.
Turning to page 3 and matters presented by Director Bechtel and the Bureau of Consumer Services. It is recommended that the Commission adopt the proposed order regarding the Universal Service and Energy Conservation Plan of the Peoples Natural Gas Company and the Peoples Gas Company, LLC.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion?
Chairman, I do have a statement on this matter.
Vice Chairman.
Thank you. I would ask that my statement be entered in the record as though I read it in its entirety. Before the Commission for consideration is the proposed 2019 Universal Service and Energy Conservation Plan for Peoples Natural Gas Company and Peoples Gas Company, and the supplemental information, comments, and reply comments filed thereto. As part of their proposed 2019 USEP, the Peoples Company sought to reduce the energy burdens associated with their customer assistance programs. The Peoples Company also proposed to eliminate the $5 copay for CAP customers with pre-program arrearages and the $5 CAP Plus charge for all CAP customers. In their supplemental information, the Peoples Company provided cost estimates related to the proposed changes, including projected data for 2020 through 2024. As discussed in its comments and reply comments, the Office of the Consumer Advocate does not agree that the energy burdens and the copay amounts for arrearage forgiveness and the CAP Plus amount should be changed at this time. The OCA submits that referral of these issues to the Commission's Office of Administrative Law Judge may be appropriate. While I do believe that a referral to OALJ is necessary at this time, while I do not believe that a referral to the Office of Administrative Law Judge is necessary at this time, I share the OCA's concerns about the cost impacts in reducing energy burdens and removing other payment responsibilities for CAP customers. Costs for the Peoples Company, CAPs, are recovered from non-CAP residential rate payers regardless of income. As I have noted in prior universal service proceedings, the Commission must ensure the universal service programs are operated in a cost-effective manner. The Commission must also balance the interest of the residential customers who benefit from the programs and the residential customers who pay for the programs. This balance is very important for those households with low or moderate incomes who do not participate in customer assistance programs and whose incomes place them just beyond the eligibility requirements for these programs. The proposed order before us today directs the People's Companies to track the data related to these cap payment changes for review during their next USAP. I agree with the proposed order, but I also encourage the People's Companies to take more immediate action if cap costs increase beyond the projected budgets. The Commission recently approved a joint petition for settlement in Duquesne Light's 2020 to 2025 USAP, which contains a provision whereby Duquesne Light will notify the parties of the proceeding and seek their input if use cap costs will exceed the projected budget by 10%, and file a petition with the Commission explaining the cost increases and outlining possible cost containment measures. I believe a similar provision should be considered for all USAPs. The People's Company's proposed 2019 USAP will be in effect for at least 5 years after it is approved. The People's Company's next proposed USAP is not due until April 1st of 2028. For the 5 years starting January 1st, 2029, for the 5 years then starting from January 1st, 2029. The Commission should not wait until 5 years or more have passed to address any disproportionate cost impacts to the residential customers who are paying for the People's Companies caps. To that end, I encourage the People's Company to notify the parties of the proceeding and seek their input if cap costs will exceed the annual projected budget of 10%, and to file a petition with the Commission explaining the cost increases and outlining possible cost containment measures. Thank you.
Thank you, Vice Chairman Coleman. Any further discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 3-0.
Continuing at the bottom of page 3, it is recommended that the Commission adopt the proposed order regarding the petition filed by the Duquesne Light Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 4, it is recommended by Executive Director Mendelson that the Commission adopt the proposed order appointing Larry Ditty to the Damage Prevention Committee as the designee for the Secretary of the Pennsylvania Department of Transportation.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 5, in matters presented by Director Sophie and the Office of Special Assistants, it is recommended that the Commission adopt the proposed opinion and order in the informal investigation of the PUC Bureau of Investigation and Enforcement versus Columbia Gas of Pennsylvania.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Is there any discussion? I do have a motion to offer during discussion, and I'm going to turn over the gavel to Vice Chairman Coleman, as I made that mistake last time and did not do that.
Thank you, Chairman. We recognize you for the purpose of your motion.
Thank you very much. I ask that my motion be spread upon the record in its entirety. On February 8th, 2019, the Commission's Independent Bureau of Investigation and Enforcement, our BINE, initiated an informal investigation of Columbia Gas of PA, Inc., relating to alleged overpressurization events that occurred on Columbia Gas's Fayetteville and Harrisburg distribution system. Specifically, the alleged overpressurizations occurred between January 9, 2018 and January 12, 2018 on the Fayetteville distribution system, and between May 16, 2018 and June 12, 2018 on the Harrisburg system. On June 8, 2021, I&E and Columbia Gas filed a joint petition for approval of settlement with respect to the informal investigation conducted by I&E. Both parties filed statements in support of the settlement. The parties submit that the proposed settlement is in the public interest and is consistent with the Commission's policy statement at 52 PA Code, Section 69.1201. Factors and standards for evaluating litigated and settled proceedings involving violations of the Public Utility Code and the Commission's regulations. The proposed settlement provides that Columbia Gas agrees to pay total civil penalty of $535,000, not recoverable in rates. Additionally, Columbia agrees to an extensive list of modifications of business practices with regard to how the utility inspects, monitors, maintains, and operates bypass valves across its Pennsylvania service territory. The Commission issued the tentative order requesting comments regarding the proposed settlement on February 3rd, 2022. On February 24th, 2022, comments to the proposed settlement were received from Richard C. Culbertson, the Office of Consumer Advocate, and from Columbia Gas. Upon review of the settlement and statements in support of the same, the limited record and the comments filed in response to the tentative order, I believe that the further development of a complete record is necessary before the Commission renders a decision on appropriate remedies in relation to the Harrisburg and the Fayetteville system events. It is clear from the OCA's comments and those submitted by Columbia Gas itself that the settlement is not clear on the issue of exactly what facilities required replacement. In addition, the parties appear to be in disagreement about Columbia Gas's ability to seek recovery of the cost of replacement facilities in rate base. Finally, the record is not clear on what damage to customer property resulted due to the overpressurization events. These issues will be elucidated further in order for the Commission to rule and make a well-reasoned decision on whether the settlement terms are in the public interest. Therefore, I move that 1, the joint petition for approval of settlement filed on June 8, 2021 between the Commission's Bureau of Investigation and Enforcement and Columbia Gas of PA, Inc. is denied. 2, that this matter is referred to the Commission's Bureau of Investigation and Enforcement for such further proceedings as deemed necessary and appropriate. 3, the Office of Special Assistance shall prepare an opinion and order consistent with this motion. 4, a copy of the opinion and order shall be served on the Office of Consumer Advocate, the Office of Small Business Advocate, and Mr. Richard C. Culbertson. That's my motion.
Motion's been properly moved. Is there a second?
Second.
Any discussion? Any objections? All those in favor, please say aye.
Aye.
Aye. Any opposed? Motion carries 3-0. And unless there's any objection, we will use the previous roll call to amend the motion consistent with the motion. Thank you. And I'll return the gavel to the chairman.
Thank you very much.
Continuing on page 5, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint of Charles Evans Hunnell versus the West Penn Power Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion?
Chairman, I do have a motion on this matter.
Vice Chairman Coleman.
Thank you. I would ask that my motion be entered the record as though I read it in its entirety, and I ask for your indulgence this morning. For those of you who have been with us in the past, I think you're familiar with some of the matters before us this morning on this case, but I think it's necessary to go through in some detail for the record. Before the Commission for consideration and disposition are the exceptions filed by West Penn Power Company of the initial decision issued on August 30th, 2021 in this proceeding. The initial decision denied in part and sustained in part the formal complaint filed by Charles Hunnell For reasons stated below, I move that we grant the exceptions of West Penn, reverse the initial decision in part, and dismiss the complaint. On May 29, 2020, Mr. Hunnell filed a complaint against West Penn over the company's proposed use of herbicides on his property. Mr. Hunnell owns a parcel of 136 acres over which West Penn maintains a transmission line in a right-of-way that crosses his property. Mr. Hunnell asserts his belief that West Penn could manage the vegetation in its right-of-way through other means. West Penn filed an answer in new matters to the complaint. West Penn denied that its proposed application of its transmission vegetation management and maintenance program constituted unreasonable, inadequate, or unsafe service. The company denied that the herbicides identified in the work plan presented any real or potential threat to the complainant or his property. The company also provided evidence that herbicides had been used in the right-of-way before and that there was no evidence that any impact to wildlife, drinking water, or groundwater. On August 30th, 2021, the Commission issued the ALJ's initial decision in which the ALJ sustained in part the complaint. The ALJ found the complainant met his burden of proof in showing that it was not necessary for West Penn to apply herbicide on those areas of the right-of-way where the complainant mows and vegetation is not overgrown. The Commission's review of West Penn's service in this proceeding is governed by Section 1501 of the Public Utility Code. Section 1501 requires that public utilities furnish adequate, efficient, safe, and reasonable service and facilities. West Penn is therefore obligated to both maintain the electric transmission facilities on the complainant's property and to manage the vegetation of the right-of-way in such a manner to ensure the electricity is transmitted safely, reliably to those customers served by these lines. I agree with West Penn that the complainant must be decided on the issues of whether the proposed use of herbicide was a violation of the Public Utility Code. The Commonwealth's Court in Pennsylvania has held that the Commission must first find there's been a violation of Section 1501 in order to sustain a service complaint. The Commission is obligated to adhere to the Court's precedent in the adjudication of formal service complaints. In this proceeding, the presiding ALJ held that West Penn's proposed use of herbicides to maintain the right-of-way was reasonable and not a violation of Section 1501. As the ALJ did not find that West Penn was or would have been in violation of Section 1501, the complaint should not have been sustained. Nonetheless, the ALJ sustained the complaint despite finding no violation and instead held that the use of herbicides was unnecessary to the extent that the property owner could maintain the right-of-way through his own efforts, with West Penn serving as a backstop to ensure the safety and reliability of operations of the transmission facility. I'm not aware of any legal authority that would allow the Commission to reassign in whole or in part the Section of 1501 obligations to maintain safe and reliable electric service to the property owner. The Commission's authority must arise from the express words of the statute or by a strong and necessary implication of those words, and the legislative grant of power to act in any case must be clear. I agree that the record supports the conclusion that there was no violation of Section 1501. The complainant, as the moving party, had the burden of proving his claim that West Penn's proposed use of herbicides was in violation of Section 1501. Any finding that a violation did occur must be supported by substantial evidence. The complainant was not qualified as an expert witness on the use of herbicides in the management of public right-of-way, of public utility rights-of-way. The complainant only offered his opinion, lay opinion, that the use of chemical herbicides on his property was unsafe. The Commonwealth Court recently reversed the Commission's order, where the Commission had relied on personal lay opinion of a property owner to sustain a complaint and to restrict the use of herbicides in electric transmission right-of-way. In that case, the Court held that the Commission erred because the lay opinion testimony it relied on did not constitute substantial evidence. The electric utility in that case had provided expert witness testimony that the herbicide was a reasonable and safe method for managing vegetation in the electric transmission right-of-way. In this proceeding, As in the prior case, the electric utility has provided expert witness testimony that the use of herbicides was a necessary, reasonable, and a safe method for controlling vegetation in the right-of-way. In this matter, West Penn provided the testimony of two expert witnesses. The first expert witness, a certified arborist, testified that effective control of vegetation within the right-of-way required the use of herbicides. The other expert was qualified in the application and safety of the proposed herbicides and the impact or the lack thereof of any environmental impact of the complainant's property. This expert testified that the proposed herbicides were approved for the control of vegetation by the United States Environmental Protection Agency and the Pennsylvania Departments of Agriculture and Environmental Protection. Based upon the record before us and the applicable law, I find that West Penn's vegetation management approach for this property was not in violation of Section 1501 of the Public Utility Code or any other regulation or order of this commission. Accordingly, as the complainant did not meet his burden of proof, the complainant cannot be sustained. I will move that the exceptions be granted in their entirety and that the complaint be dismissed. The Pennsylvania General Assembly has declared that electric service is essential to the health and well-being of its residents, to the public safety, and orderly economic development. The General Assembly has also declared that the reliability of electric service depends on the conscious inspection and maintenance of utility service, and charged that the Commission was developed and enforcing regulations for the inspection and maintenance of these facilities. The Commission has promulgated these regulations and reviews and approves electric utility vegetation management plans prior to their implementation. The Commission's most recent report on electric reliability documented that trees and other vegetation are the #1 cause of outages and lost minutes of service. While I do sympathize and respect the concerns of property owners about how public utilities manage their rights-of-way, the Commission is obligated to ensure that electric service is safe, reliable, and available to customers. The evidence that has been presented in this and other similar cases is that herbicides, when properly used, are a safe, reasonable, and effective method for managing vegetation. The Commission will continue to review and evaluate all complaints based upon the evidence presented to it, and where a violation has been shown to have occurred, direct public utilities to change their vegetation management practices. I encourage all public utilities to continue their ongoing efforts to educate, communicate, and respond to property owners about vegetation management and public utility rights-of-way. Therefore, I move that the exceptions to the West Penn Power Company be granted and that the initial decision be reversed consistent with this motion. The formal complaint is dismissed, and the Office of Special Assistance prepare an opinion in order consistent with this motion. Thank you.
Thank you, Vice Chairman Coleman. You've heard the motion of Vice Chairman Coleman. Is there a second?
Second.
Second by Commissioner Yunora. Any discussion on the motion? I do have comments to put on the record. Ask that my comments be spread upon the record in their entirety, and I would just really abbreviate it. Many of it you have heard from the statements of Vice Chairman Coleman. The Pennsylvania Commonwealth Court, in an unpublished ruling, talked about a similar herbicide application case, and that was MAT2 versus West Penn Power, and made it clear that for a landowner to prevail in this type of complaint, the landowner must provide substantial evidence showing that herbicide application proposes a risk sufficient to render the utility's herbicide application unreasonable under Section 1501 of the code. The complainant here was unable to scale that legal hurdle with substantial evidence, and as such, the complaint should be denied, and West Penn's exceptions should be granted. In the case before us, West Penn's witness stated that it would not spray herbicides on any segment of the right-of-way which the complainant mowed because the incompatible vegetation on that segment, if there's any, and that it would be too short to warrant herbicide treatment. Given this testimony, I believe that with reasonable communication from West Penn to the complainant regarding the spraying schedule for its right-of-way, there's room for this landowner and the utility to find a compromise. And I just ask that both parties attempt to work together to reach a mutually agreeable resolution. Any further discussion on the motion? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0. Is there any objection to taking the previous roll call on the matter as amended? Seeing no objection, the matter as amended passes 3-0.
Turning to page 6, it is recommended that the commission adopt an omnibus motion, both items on page 6, beginning with the complaint of the PUC's Bureau of Investigation and Enforcement versus TL Trucking, and ending the omnibus with the informal investigation of the PUC Bureau of Investigation and Enforcement versus Verizon Pennsylvania LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 3-0.
Turning to page 7, it is recommended that the commission adopt the proposed opinion and order in the tariff supplement and rate proposal filed by Aqua Pennsylvania Water and Wastewater.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yunora. Any discussion?
Madam Chair, I have a motion on the matter.
Commissioner Yunora.
Thank you, Madam Chair. I ask that my motion be entered into the record as if I read it in its entirety. Before us today is Aqua's proposed combined water and wastewater rate increase filing. In its filing, Aqua requests a management performance adjustment to its return on equity, or ROE, claim. I recognize Aqua's significant efforts and willingness to quickly provide emergency aid to various water and wastewater systems that needed substantial improvements. Over the past 5 years, Aqua has provided emergency aid to protect both the public drinking water and Commonwealth's environmental resources from catastrophic damage. To date, Aqua continues to operate 3 troubled water and wastewater systems under emergency receivership throughout the Commonwealth, including the North Heidelberg wastewater system, Twin Lakes water system, and James Black water system. Aqua has answered the call to provide emergency assistance for these systems at the request of the public, public advocates, and government agencies. Given the nature and the frequency of these emergencies, Aqua should be recognized for its efforts to serve as a ready and willing ally in the water and wastewater emergencies, affording Aqua the most management efficiencies adjustment to its ROE because of its explanatory emergency services is just, reasonable, affordable approach to address its ongoing emergency aid efforts. Therefore, to reflect the extraordinary efforts exhibited by Aqua to aid to protect the Pennsylvania water and wastewater customers and the environment, Aqua should be awarded the additional 25 basis points to the ROE for a total ROE of 10%. Therefore, I move that the Aqua exception number 1.6 is granted and the company shall be awarded the management performance adjustment of 25 basis points to its ROE for a total ROE of 10%. Second, that the Office of Special Assistance prepare an opinion and order consistent with this motion. Thank you, Madam Chair.
Thank you, Commissioner Yunora. Any discussion on the motion? Hearing none. All those in favor, please say aye.
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 Any opposed? I am voting no on the motion. The motion passes 2-1. On the matter as amended, is there any discussion? I do have comments to place on the record for discussion on the matter as amended and ask that my comments be spread upon the record in their entirety as if I read them in their entirety, but I will not read them in you guys have more things to do than listen to my entire statement. But here it goes. Before us is the base rate case filed by Aqua Water and Wastewater. Aqua requests a management performance adjustment to its return on equity, or ROE. The company contends that it continues to assist the Commonwealth in dealing with problems created by small, troubled, and non-viable water and wastewater systems. Of note, I referenced the company's assistance with North Heidelberg Sewer Company, Twin Lakes Utilities, and James Black Water Service Company. In each instance, the company is serving as receiver, assisting this commission to ensure the public in these service areas is provided safe and reliable service. As well, the company has shown that it provided COVID-19 assistance to its customers and other utilities. The record here indicates the company provided assistance to low-income customers via arrearage forgiveness, while also distributing over 50,000 masks to other water and wastewater utilities in the state. Further, the company details its continued diligence in managing emerging contaminants. Aqua explains that it has committed to installing mitigation technology at its water treatment facilities where sources of supply exceed 13 parts per trillion for PFAS and PFOA. This level is below the United States Environmental Protection Agency's present health advisory level of 70 parts per trillion. This commission has granted management performance adjustments to ROE in previous rate cases. As the company's expert witness states, increments for management performance granted by the commission have ranged from 0.05% to 0.25%. Here, I do believe the results of Aqua's management performance justify an adjustment of ROE upward by 10 basis points. This would result in an overall ROE of 9.85%, which still remains in the range of reasonableness detailed by our INE. The adjustment would increase annual revenues by approximately $2.9 million. I believe such an adjustment appropriately acknowledges the performance of the utility while also taking into consideration the cost burden placed on customers. Further, I would like to take the time to acknowledge the commitments Aqua has made towards implementation of a comprehensive universal service program. Aqua proposes to replace its existing Helping Hands program with a tiered customer assistance program, or CAP. The proposed CAP, quite similar to design to those offered by energy utilities, will provide tiered bill discounts and arrearage forgiveness to low-income customers in order to tackle household water and wastewater affordability. The tiers would be set at 100% of federal poverty guideline, 150% of federal poverty guideline, and 200% of the federal poverty guideline, with the highest level of discounts provided to the first tier and gradually reducing. The company also proposes to include an emergency prepare program focused on distributing conservation kits and providing customers with emergency leak repairs. I'm pleased to see these significant expansion in customer assistance programs. I would like to acknowledge also the hard work and commitment of the Commission's Office of Special Assistance in this case. The OSA management team and staff have worked diligently to shepherd this very dynamic and voluminous proceeding to conclusion in a timely manner, a feat worthy of recognition. So I do thank OSA. In conclusion, I am voting in favor of this matter as amended. While I do not support the 25 basis point ROE increase, I do believe the results of the remaining components of this proceeding reflect a fair and reasonable outcome for the utility and its customers. Any further discussion on the matter as amended?
Madam Chair, when Commissioner Ginor made his motion, was there a second?
Yes.
I will second it for the record.
Second, all right.
If I didn't, I will.
I thought you did second.
No,
I'm sorry.
we had a vote, but I don't think we had a second, so I want to make sure.
I thought there was. We are on the matter as amended, though, right?
Yes,
Okay.
yes, now.
All right. On the matter as amended, any further discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Any opposed? The matter as amended passes 3-0.
Continuing on page 7, it is recommended in an omnibus motion that the Commission adopt the remaining item on page 7, the settlement between the Safety Division of the Bureau of Investigation and Enforcement versus the People's Natural Gas Company, LLC, and continuing the omnibus on page 8 to include all 3 items on page 8, ending the omnibus with the joint petition of Verizon Pennsylvania, LLC, and Everstream Solutions, LLC.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 9, and matters presented by Director Diskin and the Bureau of Technical Utility Services. It is recommended in an omnibus motion that the Commission adopt both items on page 9, beginning with the application of PennDOT, and continuing the omnibus to include all 3 items on page 10, all 3 items on page 11, all 3 items on page 12, and including and ending the omnibus with the single item on page 13, the security certificate filed by the Newtown Artesian Water Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 14, it is recommended by Chief Counsel Hicks and the Law Bureau that the Commission adopt the proposed order regarding the final annual report of Act 129, Phase 3.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? I do have comments and ask that my comments be spread upon the record as if I read them in their entirety. Before the Commission is the Act 129, Phase 3 Final Annual Report. The report details the results of various energy efficiency and conservation program measures implemented by the state's largest EDCs pursuant to Act 129 of 2008. The report is utilized as a basis for determination of whether or not each applicable EDC is compliant with the mandates set forth by this Commission. The release of this report represents another milestone in the implementation of Pennsylvania's EE&C programs. Phase 3 ran for 5 years from June 1st, 2016 through May 31st, 2021. During this time period, all EDCs complied with their energy savings targets, resulting in over 6.6 million megawatt hours saved. That is enough electricity to power more than 630,000 homes for 1 year. Further, the demand reduction programs resulted in savings of 904.5 megawatts. The overall cost over the phase was $1.8 billion, while overall cost savings came to $2.6 billion. This results in approximately $750 million in net benefits for Pennsylvanians. I'd like to thank our staff at the Commission, our statewide evaluator, the EDCs, and the various conservation service providers for their hard work and diligence toward implementation of Act 129, past, present, and future. I am pleased to vote in favor of releasing this report to the General Assembly and to the public. I believe it exemplifies the continued benefit targeted investment in energy efficiency. As I have said before, the cheapest kilowatt hour is the one not used. Any further discussion on this matter? Hearing none, all those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Turning to page 15, and matters presented by Chief A.L.J. Rainey and the Office of Administrative Law Judge. It is recommended that the Commission adopt A.L.J. Long's recommended decision in the formal complaint of Tim McKercher et al. Versus the Hanover Municipal Water Works.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Aye. Any opposed? The motion passes 3-0.
Continuing at the bottom of page 15, it is recommended that the Commission adopt A.L.J. Johnson's initial decision in the formal complaint of Stephen and Nancy Ulishny versus the West Penn Power Company.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Yenora. Under discussion, I do have a motion to offer, and I ask that Vice Chairman Coleman would preside.
Thank you, Chairman. We'll recognize you for the purpose of your motion.
Thank you very much, and I will read my motion in its entirety. Before the Commission for consideration is the complaint filed on February 16, 2021 by Stephen and Nancy J. Ulishny, alleging that their refrigerator was damaged by the numerous recloser events that occurred on the distribution line serving their residents. Following a pre-hearing conference attended by both parties, an on-site investigation, and a number of postponements, the evidentiary hearing was scheduled for January 11, 2022. By email dated December 23, 2021, West Penn served the complainants with a motion to compel discovery. By email dated December 24, 2021, sent to West Penn's attorney and the administrative law judge, the complainant stated that they no longer wanted a hearing. By email dated January 7, 2022, West Penn requested that the hearing scheduled for January 11, 2021 be converted to a pre-hearing conference to discuss its motion to compel discovery. January 7, 2022, the ALJ emailed the parties and informed them that the hearing would proceed as scheduled and that West Penn's motion would be addressed at the hearing. Later that same day, via email, the complainants responded to the January 7, 2022 emails. The complainants referenced their December 24, 2021 email containing their statement that they no longer wanted a hearing, adding that because the Commission cannot grant damages to complainants, they had no further use for the Commission or the scheduled hearing. The hearing was convened as scheduled on January 11, 2022. The complainants did not appear. ALJ Johnson granted West Penn's motion to dismiss the complaint with prejudice. Section 5.94A of the Commission's regulation provides that a party desiring to withdraw a pleading in a contested proceeding may file a petition for leave to withdraw the appropriate document with the Commission and serve it upon other parties, and that's in our regulation section 52 PA sections 5.94A. Section 5.94 further provides that the petition must set forth the reasons for the withdrawal and that a party may object to the petition to withdraw within 10 days. The complainant's December 24, 2021 and January 7, 2022 correspondence clearly communicated that they did not intend to pursue their complaint before the Commission. I believe that the complainant's email correspondence should have been deemed a petition for withdrawal of their complaint. Having considered the petition, I find there is no harm to the public interest in granting the complainant's request to withdraw their complaint. Since the Commission must also consider any objections to the petition, it is appropriate to establish a 10-day objection period as set forth in section 5.94. Therefore, I move that the complainant's December 24, 2021 and January 7, 2022 emails shall be deemed a petition to withdraw consistent with 52 PA Code section 5.94. 2, if no objection to the petition to withdraw is received within 10 days of the entry date of the opinion and order in this matter, the petition to withdraw shall be deemed granted and this docket shall be marked closed. And finally, the Office of Special Assistance shall prepare an opinion and order consistent with this matter. Thank you very much.
Thank you, Chairman. The matter has been properly moved. Is there a second? Is there a second to the motion?
Second. Second.
Any further discussion? Any objections? All those in favor, please say aye.
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 Any opposed? Motion carries 3-0. And unless there's any objection, we'll use the previous vote to amend the motion consistent with the motion. Thank you.
Thank you.
Turning to page 16. It is recommended in an omnibus motion that the commission adopt both items on page 16, beginning with ALJ Heap's recommended decision in the supplement and rate proposal of the City of Lancaster, and the initial decision of ALJ Johnson in the joint application filed by the Peoples Natural Gas Company, LLC, and Peoples Gas Company, LLC, and continuing and ending the omnibus on page 17 with ALJ Dunderdale's initial decision in the formal complaint of Three Sons Food LLC, Fox's Pizza Den versus the West Penn Power Company.
Is there a motion to adopt the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Madam Chairman, that concludes regular agenda. Turning now to the carry-in. On page 1 of the carry-in agenda, it is recommended by the Law Bureau that the commission adopt the notice of proposed rulemaking for the use of the fully projected future test year.
Is there a motion to adopt the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Vice Chairman Coleman, second by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
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 Aye. Any opposed? The motion passes 3-0.
Madam Chairman and Commissioners, that concludes all agenda items to be considered today.
Thank you very much, Madam Secretary. Before we do close the day, I would like to take a moment to recognize Memorial Day Remembrance, which will take place in a few weeks. Let us take this Memorial Day as a time for us as a nation to express our gratitude for the unthinkable sacrifices made by servicemen and women risking their lives for the safety of our country and its ideals. As we all enjoy the long weekend and an additional day off, please remember the reason we celebrate Memorial Day and the sacrifices of others. On behalf of my fellow commissioners, I wish everyone a healthy and safe Memorial Day weekend. I would also like to note that the public meeting for May 26th has been canceled, and our next public meeting is scheduled for Thursday, June 16th. So with that, I will entertain a motion to adjourn.
So moved.
Second.
I didn't even have to ask for a second. All those in favor of adjourning, please say aye.
Aye.
Aye. Any opposed? Motion passes 3-0. We are adjourned. Thank you, everyone.